correct this way, member for Sandimentary constituency, because by adding only member, it's showing that I'm a member of a particular committee. But in this case, I'm even more than, I'm not only a member of this committee, I'm the vice chairperson of this committee. So I think it is correct as amended. Thank you.
Honorable members, I think we can leave it as it is and then we proceed. Am I right? Yeah, as amended. All right. Now, we now move to page 8. Honorable Member for Sabak Sanjar.
Thank you very much, Honorable Speaker. If you look at on that paragraph on the neat end of debate, it says at the invitation of the Honorable Speaker, Honorable Patu Cham and co-vice chairperson and mover of the motion. I think it should read as Honorable Patu Cham, co-vice chairperson and mover of the motion. The repetition of "and" might be avoided.
Thank you very much. You are right. Honorable Fatu Cham, the "and" should be removed. Co-vice chairperson and mover of the motion responded to issues raised and one of the debate.
Thank you very much, Honorable Member for Sabak. Any more on page 8?
Honorable Member for Jara Central.
No, Speaker, that would be on page 9.
We are on page 8?
Yes, thank you.
Any more on page 8? Honorable members, we now move to page 9. And the Honorable Member for Jara Central, you can come in.
Thank you very much, Honorable Speaker. Page 9 would be the last paragraph. Sorry. After end of debate, the second paragraph. Question put and agreed to. The report was unanimously agreed. Roman number 5. Report of the Gambian delegation to the 64th session of the Organization of Africa. It should be African, Caribbean, and Pacific states, and wherever it may appear, because it appears also on page 2. Thank you.
Noted. Thank you very much, Honorable Member for Jara Central. Honorable members, we now move to page 10. Thank you very much. Honorable members, it has been moved and seconded that the record of votes and proceedings of the National Assembly sitting of Thursday, 4th July 2024, be approved with amendments. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Thank you very much, honorable members. Clerk, may we now proceed?
Laying of papers and reports. Report of the National Assembly Joint Committee
of Health and Gender on the Women's Amendment Bill 2024 by the Honorable Co-Chairperson of the Joint Committee.
Thank you, Clerk. May I now invite the Honorable Co-Chairperson of the committee to table the report.
Motion, Honorable Speaker. Point of
Yes, who is Honorable Member for Lower Salum? What do you want?
I want to move a motion 61-3.
What is that?
2-3.
61, it says clause 61-3. Am I right? Standing order, I in reference.
I move 53K motion without notice from there 61, 2 and 3.
Honorable Member for Lower Salum, you want to move a motion with making reference to clause 53K, huh? To the Speaker's discretion. Now, I have not heard your motion, but can we hear your motion, please? Then I'll make a determination.
Yes,
Honorable. Making reference to 61 and 61, 1 and 2, huh? 2 and 3. Yeah.
Yes, 61-2, Honorable Speaker. If you point to read, the Assembly may on a motion made by the Assembly Business Committee in accordance with the standing orders impose a limit in respect of a debate on a particular motion or bill by allotting a time period for such debate, or by limiting time during which member may speak in such debate, or by imposing both such limitations. 3, a motion for limiting a debate under the standing orders may be made without notice. Honorable Speaker, I rise and move this motion, giving members an ample time to on this particular subject to debate on time 10 minutes for open debate based on the magnitude of this report. Yes, to suspend our earlier decision.
Honorable, I'm not getting what you want. You are moving a motion to suspend what? Increase members. Can you allow him say what he wants to say?
To increase the debate for 2 hours for members.
We cannot increase the time allotted because a motion had earlier been moved.
This was the reason why I was making this inquiry. And you said, unless we will reach at that time. That was your ruling.
Honorable members, Parliament has a process. decision was made at that particular time as per our order papers, agenda rather, at the time. Today, we are looking at the health report, which is part of the motions allotted time. Parliament has a process. If Parliament wants to change from what they have decided, there is a process.
Honourable Speaker, Honourable Speaker.
Yes, Honourable Member for Lower Sal.
Thank you very much, Honourable Speaker. There is a discussion 53K. I rise to move our earlier decision on this matter for this particular business to be rescinded. Yes.
Honourable members, I refer honourable members to clause 29, stop 3. Can any honourable member please read that clause? Sub 3, eh? 29 sub 3.
Okay, it reads. It reads, it shall be out of order to attempt to reconsider any specific question upon which the Assembly has been taking a decision during the current session, except upon a motion to rescind that decision, that which notice must be given.
Now, Honourable Speaker, I move a motion at your discretion, 53K. You understand?
Honourable member for Lower Salum, may I hear you said?
My motion is 53K at your discretion to be put as a matter of urgency, whereby, to rescind our earlier decision, because that was the reason why, in my debate, when this time allowed to come in, you said to us, unless we reach at that particular time. You understand? So that was the reason why members vote for it. But this was my point.
Honourable members, while I sympathize with this situation, Speaker's discretion only comes in where the standing order is silent. Where the standing order expressly states that for a motion to rescind a decision, notice must be given. I don't think I have discretionary powers to put that aside. And even where Parliament, I observe, even where Parliament wants to put away or suspend a portion of the standing orders, that still means notice has to be given.
Honorable Speaker.
Let's take somebody else. No, let's take somebody else. Honorable Member for Nyamina Danku.
Thank you, Honorable Speaker, for giving me the floor. Honorable Speaker, when we started debating the issue of this amendment, the Women Amendment, during the process of debate, we debate until at a time a motion was moved by the minority leader. And what was moved was for us to suspend the debate. Then we refer it to the committee. If the committee report back, we now combine the two, the continuation of debate and the motion. So giving us only 1 hour, for us to consider the report and debate on the continuation is definitely not doable if we want to do justice. And then we have to understand, we have to convince one another before we make decisions.
Honorable Speaker, Honorable Majority Leader and Member for Kantora.
Thank you very much, Honorable Speaker, for giving me the floor. I think we have to deal with procedural matters here. The substance here is about, can we use Standing Order 53K with your permission or discretion to move a motion? That's one. But in an event, there is a law, a standing orders. If you want to rescind a decision made by the person in a session, or to rescind the decision, you have to make sure that you notify the Speaker. Making reference to what has been discussed, that could have informed the ABC committee then for not making decision on 1 hour. Issue of we have suspended the debate and saying let the committee go, that will suffice, will make relevant points at the ABC during the time allocation, not at this moment. So I think the argument advanced by Prof. Nyamidanku is not really in line with what's happening here. So I would urge the chair to make a ruling on this. Either we go by what has been moved by the Assembly Business Committee for us to debate within 1 hour, or otherwise. But I think procedurally we are in order. You can proceed. Thank you.
Honorable Speaker. Honorable Member for Brikama North and Minority.
Honorable Speaker, it could be recalled the first day when this issue of time allotted to particular issue was raised by the Honorable Member for Lower Salu. He indeed made reference to the issue specifically on this particular subject, that it will require time. What he was advised that day was the matter or the matters on the table that day were not contentious. And therefore, members agreed we could go by the time allotted to those matters. If comes where we have contentious matters like this, he can raise a motion for that decision to be rescinded. If to add the time, then we can do so. Perhaps there could be miscommunication and procedures could not be taken, but this was the agreement. So where do we strike the balance? Where do we strike the balance? But that was the promise given. And Honorable Speaker, there was miscommunication to follow that procedure, and we could not meet it. I advise and appeal, we strike the balance.
Honorable Speaker, honorable members, let me have the honorable nominated member, Keba Lang.
Honorable Speaker. Honorable Speaker. Thank you very much, Honorable Speaker. Honorable Speaker, we are in a catch-22 situation.
One, with regard to our rules, the rules guiding us as prescribed in section 29.3, the commitments we took on the floor of this House. When the issue of limitations with regards to how much time a member can be allotted to partake in debate was taken on this floor, what was communicated was it wasn't a general rule. It was on specific basis, and will be availed the opportunity to discuss as the need arises. And I believe it is premised on those bases that the honorable member for Lower Salem made the proposal. So I'll also be part of the individuals or the honorable members who will seek your indulgence to really look into the issue and see how best we can improve on the time allocated. Because that was the promise the House delivered. Thank you.
Honorable member for Lower Fladu.
Thank you very much, Speaker. I think, first and foremost, we have never agreed here. It was a suggestion. And as far as you can give us 2 hours, 3 hours, we are ready to debate. The substance and the facts can never change. Anything they want, we are ready and we are going to debate. But it was never an agreement, it's a suggestion. And I'm going to move a counter motion that we stake on this.
Honorable members, I think we have... Honorable Speaker. Honorable members, please. I have listened to most of you. I cannot listen to all. I have listened to most of you. And, please.
Mr. Speaker.
Speaker. Who is talking? Kian West. Kian West, please sit down. Please. Stand up. Please, I am talking, please. I am not giving you the floor, Kian West. Listen first. So that you can have a fair decision. This is why we are please. Don't disturb the process, please. Please. You are limiting us to do our work. Honorable member, please don't make me say something contrary to what my opinion is. Please, if I give you that chance to please sit down and be quiet. I have said to you many a times that go by your standing orders. When the speaker is speaking, you sit down and listen. You don't talk. How many times do you want me to say that to you? You see, this is not a debate. This is not a debate. I am to take decisions. I granted opinions on the floor for better explanation and for me to be able to make an informed decision. The arguments or whatever one will say will be either this side or the other side. Honorable members, I've heard you well. I have heard both sides. Those who are agreeing that on that fateful day, when time was allotted to 1 hour, there are plans for the honorable member for Lower Salem, who was trying to criticate to see whether it could be changed. And we said no. He's talking about something. When the time comes, we deal with it. I think that's the basis of their agreement. Even if that is so, it follows a parliamentary process. Knowing that already a motion had been moved to allot time, and that there is need for us to change the time at a particular time during the course of the session. And bearing in mind clause 29.3, then a motion, notice will have been given for a possible motion to rescind that decision today. The whole thing is a process. Now, we now find ourselves in this catch-22 situation. where members, I observe probably, want to debate more than the time allotted. We are restricted by our own laws. And you are appealing that the Speaker uses discretion. And what I said is, my discretion comes in where there are no fixed provisions. But where provisions say you go right or you go left, it will be difficult for the Speaker to have a discretion. But I sympathize with the situation, and I sincerely believe that as this particular motion, if we can increase time, I would love that. But what do we do to increase that time? Yes, Honorable Member for Banjul South.
Thank you. Mr. Speaker, we understand and appreciate everything you have mentioned, but there is a reason for clause 53K. Yes? Clause 29.3 says that we can accept upon a motion to rescind the decision for which motion must be given. Yes, motion must be given, but also you have, notice must be given, but there's also a reason for section 58K, and that 53K, and that should be at your discretion. Whether notice is given or not should be at your discretion, and that is the discretion we are asking. This matter on the table is very important. I would not even want it to be debated because it will call on our private part, and as a woman, I respect myself. But Mr. Speaker, I would also want to give members ample time to tell us what they want. This report is very important, Mr. Speaker, so please use your discretion on section 53K to allow us to speak. Thank you.
It's not the Speaker preventing you from speaking. It's your own standing laws preventing you from speaking. And two, you see, the provisions of 53K that you are quoting is meant for provisions that already are not qualified. That's where the Speaker's discretion comes in. But as I said, honorable members, read through, we all seek for legal opinion from our legal experts around. And what can we do under the circumstances to increase the time limit? Under the circumstances.
Honorable Speaker.
Honorable member for Central Badibu.
Thank you, Honorable Speaker. Honorable Speaker, I think that's why anything that we make in the Parliament, we have to be guided by procedures and rules. And it's very clear in our rules. The notice must be given to the Speaker. So let us not waste the time of the House. So any decision that you are making, you should follow your rules. That day, on that fateful day, you are making just a compromise decision not based on the rules. I'm sorry to say that.
Member for Kantora.
Honorable Speaker. Now, Speaker, like you said, I agree with you entirely. We are caught in a catch. Honorable Speaker, like you rightly said, I think for us to have a way out here is one way, one option. Either we stand down for 5, 10, 15 minutes, then we call for an all-party caucus. Please, please, please. We can stand down for 10 or 15 minutes and agree on a time frame, notify the Speaker and resume back, and then vote on that.
Point of order, Honorable Speaker. Honorable Speaker, point of order. Honorable Speaker, on a point of order. Point of order.
Honorable Speaker. No.
Yes, honorable members. Which honorable member was standing up for point of order?
Honorable member for Sabak Sanjal.
Honorable member for?
Sabak Sanjal.
Sabak Sanjal. Yes, can I hear your point of order, please?
Thank you very much, Honorable Speaker. I just want to refer the humble assembly to section 52, 1 and 4 of the standing orders. 1, 2, and 4. Okay. Honorable Speaker, if I may read, it will take time, but if members agree, they can just read through. It's very clear. It says, notice of a motion shall be given by being handed in writing to the table office not less than 5 clear days before the sitting at which it is intended to be debated. 1. 2. All notices shall be signed by the Vice President, Ministers, Committee, Chairperson, or member proposing the motion. 3. When a notice of a motion is received, the table office shall record the date and hour of its receipt and submit it to the Speaker. 4. Subject to...
Honorable, you are standing on a point of order. What is your point of order?
That's what I'm reading on. I referred you to Standing Order 52, subsection 1, 2, 3, and 4.
You have, yes, made reference to that. We have seen it. Yes, continue with your point of order.
Now, the issue here is the issue of notice. And I think the standing order is very clear. Honorable Speaker, we don't have to set precedents. Even though members want to debate on this particular motion, but we have already made a ruling on this. And our laws need to be protected. The law that guides our proceedings needs to be protected.
Honorable, yes, you've said it eloquently, but I don't think it's a point of order.
Of course. That's what I...
There is no decision yet. There are debates on various sides.
The issue of notice has been raised.
Yes, notice people are debating. Some are saying because of A, B, and C, let's do C, D, and E. Others are saying no. That's where we are. It's not normal parliamentary process. Honorable members, I think I have to take a decision. But before I do so, I will give the honorable member for Lower Salem.
Thank you, Honorable Speaker, for giving the floor again. No, Honorable Speaker, it's good also we make reference on the motion of SONA, section 77.2, where I give rights the Vice President to answer issues. But in that particular day, you impose a decision whereby you have to rescind our decision that we have made. There was a motion here, and it is a reference. It was a motion in this session that has already taken by decision by the Parliament. And again, we, the same Parliament, make that decision to rescind that decision on that very day, where we allow the Minister to come to the podium and answer issues. And in the same article, session. So let's see.
Honorable member, are you challenging my decision?
I was just trying to make a reference, sir.
Because already, know that if you are to challenge the Speaker's decision, it must be on a substantive motion. Honorable members, as I said earlier, we find ourselves in this catch-22 situation. Honorable minority, you want to say something?
Honorable Speaker, something. Exactly, Honorable Speaker. How do we get ourselves from the catch-22 situation? That is the big question. And before the Honorable Speaker will humbly decide and take into cognizance the appeal from the members. I refer you to clause 8, 1 and 2. 1 and 2, page 8. In the cases where the matters are not expressly provided by these standing orders, any question on procedure or order shall be wait. I'm concluding to something. To something, please. I know what I'm reading, and I know where I'm going to conclude. Procedure order shall be decided by the Speaker. In 2, decisions made in paragraph 1 shall be based on the Constitution, the status law, or the precedents. I underline that. Until customs, procedures, traditions, I underline that. That is of the Parliament. Honorable Speaker, all is vested on you. As rightly alluded, there were incidents that will be rescinding without actually taking the due process for notification to be given to the Speaker. And the Speaker, based on the prevailing circumstance and conditions, hopefully accept, and that's why I'm appealing with the prevailing circumstance. Hopefully, let's go by that best practice and accept. We extend the time to 2 hours.
Honorable members, I know parliamentarians, you are experts in trying to get to where you want to get to. But the honest thing here is, the minority leader quoted various clauses of the standing orders, rightly, and that there is this urge that we give members more time on this particular issue to convince each other. But I want to buy the idea of the honorable member for Central Badibu. You know, at the time some of these decisions were made, Parliament has a process. If we agree at that time that we may look at some of these things again, it will have allowed members to have given notice for us so that today we will have done it. It's always a process. And 2, when decisions are made probably that are wrong, whether, let's assume that wrong decisions are made, it does not mean that those wrong decisions should continue. So under the current circumstances, honorable members, as I said, my own honest opinion is allow members extra time. But there are no provisions that I can rely on. Because if you look at 29.3, categorically, it is very strong. It leaves no room for maneuver. Speaker. Honorable Speaker. But it has to be, it shall be out of order. It shall be out of order to attempt to reconsider any specific question upon which the Assembly has taken a decision during the current session, except upon a motion to rescind that decision for which notice must be given. Now, Speaker, the Honorable Minority Leader made specific references to areas, yes, where we're looking at precedents. Precedents to make determinations. Yes, that's important in Parliament. But precedents, those precedents, if you hear of precedents, it means there were no regulations, and therefore decisions were made and they become precedents. But where there are regulations, you don't have those things as precedent. It means you went against your own regulation. That is precedent. That's where you come in for precedent. Honorable Speaker, honorable members, under the circumstances, honorable members, until we have the relevant provision to rely on to rescind our own decision. In the absence of that, I will, my ruling will be we go by the time allotted.
Honorable Speaker, Honorable Speaker, Speaker.
Honorable members, yes, I now invite the Honorable Chairperson of the committee. Honorable Speaker. No report.
Honorable Speaker.
Thank you very much.
Honorable Speaker.
No. I tell you this is on. No, I tell you this is on. No. No.
Honorable Speaker.
Thank you very much.
On a different issue. Honorable Speaker. On a different issue.
Honorable Speaker.
Honorable Speaker, I want to observe on a different issue.
Honorable members.
Honorable Speaker.
Honorable members. Honorable members. I have said many a times, and let me repeat it, as much as we can, as humanly possible, let's go by our own standing orders and try to respect each other as much as possible. Honorable Minority Leader, you are standing up to something different, you said. Yes, may I hear that?
Honorable Speaker, what I want to put across, if not all, most of us received this report just this morning, and there was no time to adequately go through. I'm appealing to the mover of the report, if he can read the full text of the report so that we can follow as he is reading, because we do not have the time to go through the report. Okay, that's here.
Honorable members, there was an appeal by the Honorable Member for Pikama North. I now invite the Honorable Co-Chairperson to table his report.
Thank you very much, Honorable Speaker, for giving me the floor. Honorable members and, of course, esteemed stakeholders here present, as rightly appealed, and I will go by that. Honorable Speaker, I rise to move that the report of the Joint Committee of Health and Gender on the Women Amendment Bill 2024 be adopted. Honorable Speaker, going through the report first, I will start with the acknowledgement, as they said, which is given. I don't need to go through that. Then, of course, I will move on to the introduction, which reads as the Assembly during its sittings of Monday, 4th March 2024, in the fourth ordinary session of the 2024 legislative year, witnessed the introduction of a bill entitled Women's Amendment Bill 2024 by the National Assembly member for Fonyi, Councillor Honorable Almami Jiba. On a motion for the bill to be read a second time, the general merits and principles of the bill was debated. The bill was read for the second time, and it was referred to the Assembly Business Committee for committal to the relevant committee in accordance with the standing orders. The Assembly Business Committee then referred the bill to a Joint Committee of Health and Gender. The Joint Committee was tasked to consider and scrutinize the bill and present its findings and recommendations to the Assembly. Accordingly, Honorable Speaker, the Joint Committee engaged in a thorough review process to meticulously examine each of the proposed amendments together with the overarching objectives and ramifications of the proposed legislation. Experts and relevant stakeholders' opinions were sought to ensure a well-informed scrutiny.
The Joint Committee, having considered and scrutinized the bill together with all the experts and witness testimonies, hereby present its findings, observations, and recommendations contained in this report. The mandate of the committee. In accordance with Standing Order 69 of the Standing Orders, the mandate of the Joint Committee was to A. Consider and scrutinize the Women Amendment Bill 2024, B. Identify witnesses and gather evidence on clause-by-clause consideration of the bill, C. Record the opinion of the Joint Committee on each clause of the bill, focusing on any proposed amendment, D. Consider amendments in order in which they stand in the bill, and E. Provide a report comprising a summary of evidence gathered from witnesses, the opinions of the Joint Committee on the clauses of the bill, and the amendments proposed. The proceedings also read as follows. The Joint Committee relied on the testimonies of witnesses and the position papers presented to it to review the proposed amendment clauses of the bill, clause by clause, taking cognizance of the overall objective and ramifications of the proposed amendment bill. Cross-references were made to ensure that the content of the bill was in conformity with the 1997 Constitution of the Republic of the Gambia, and of course, and other laws of the Gambia. And here in attached, you can see the proposed amendment, that is the Women Amendment Bill, which I don't need to read through, where you have the subtitle, the amendment of Cap 3301, and of course, you have the object and region, everything attached. We move on to page 8 now. Honorable Speaker, it is important to start with this because we are dealing with a very important issue, and it is a subject matter. That is the definition of female genital mutilation, according to the witnesses. According to the evidence received by the committee, female genital mutilation or cutting, or others call it circumcision, is the partial or complete removal of the external female genitalia or other injury to the female genital organs for non-medical reasons. It is understood to be a deep-rooted traditional belief, practice considered as a rite of passage in preparing young girls for marriage. According to the 2015 Women Amendment Act, female circumcision includes, this is also very important, this is embedded in the current law that we have, A, the excision of the prepuce with partial or total excision of the clitoris, that is clitoridectomy. B, the partial or total excision of the labia minora. C, the partial or total excision of the external genitalia, that is of the labia minora and the labia majora, including stitching. D, the stitching with thorns, straw, thread, or by other means in order to contact the excision of the labia, and the cutting of the vagina and introduction of corrosive substances or herbs into the vagina for the purpose of narrowing it. E, symbolic practices that involve the nicking and picking of the clitoris to release drops of blood, or F, engaging in any form of female genital mutilation or cutting. In most cultures in the Gambia, FGMC is performed on girls between the ages of 2 weeks to 5 years. FGMC has serious health and reproductive health consequences affecting health and well-being of girls and women. It is important to note that female circumcision is for the foreskin that is being removed, while FGMC is the female organs that are very sensitive with nerves that have been cut. Honorable Speaker, moving on to the scrutiny, findings, and recommendations. Oral and written evidence of witness. The Joint Committee consulted various witnesses. The overwhelming consensus among them was against the repeal of the ban on female genital mutilation or cutting. The testimonies underscored the imperative of upholding legal and human rights frameworks, emphasizing the severe health implications and entrenched cultural factors associated with FGMC. This perspective reinforced the necessity of continued efforts to combat FGMC and protect the rights and well-being of affected individuals. Justifications, Honorable Speaker, moving on. That is justification for supporting the repeal of the bill. It is important to note that we made different stakeholders, those who know that they are in support of the repeal, those who know that they are not in support of the repeal. So we start with those who are in support of the repeal. The religious perspective, according to the position papers and the testimonies of witnesses we received. Some of the witnesses interpreted the legality of female circumcision within Islamic guidelines, but condemned the harmful practices associated with it and advocated for a balanced approach that respects religious beliefs while safeguarding women's well-being. However, many Islamic scholars consulted by the Joint Committee within and outside of the country stated that female genital mutilation or circumcision is a custom and not one of the rituals of Islam, whereas male circumcision is part of the rituals of Islam. This clearly here, I will propose that we amend. There is a small error here. This clearly, instead of clarifies, this clearly suggests that FGMC lacks a religious basis supporting advocacy and educational efforts based on Islamic belief. The claims of FGMC being a sunnah or tradition of the Prophet are refuted by the lack of authenticity of the hadiths. It was stated that the narrations describing the Prophet, peace be upon him, advising a woman performing FGMC not to cut too much were misinterpreted by some scholars. The absence of credible religious justification further weakens the argument for FGMC, highlighting it as a harmful cultural practice rather than a religiously mandated one. The Joint Committee is of the opinion and received evidence supporting that even if the hadith was authentic, there is more authenticated hadith that prohibit harmful practice to individual health. Moving on those supporting the repeal, the second point, that is cultural tradition. The Gambia, like many African nations, has deep-rooted culture, traditions. Therefore, supporting the repeal shows respect and will empower the communities to manage their cultural practice. They also acknowledge that cultural change is gradual and should come from within communities rather than through legislative coercion. Preservation of virginity. In some cultures, FGMC is believed to preserve a girl's virginity and purify before marriage. It is seen to control women's sexuality and prevent premarital or extramarital acts. The Joint Committee is of the opinion that such a submission is not backed by any scientific evidence, and in fact, the practice has proven by medical experts that it affects women's sexuality. Hygiene and cleanliness. It is also believed that FGMC promotes hygiene and cleanliness by removing the unclean parts of a woman's body. It is believed to prevent infections and diseases, although there is no scientific evidence to support this claim. Economic and monetary gain. For some circumcisers, FGMC is used as a means of gaining revenue for sustenance. Due to this monetary gain, circumcisers are reluctant to abandon the practice. The Joint Committee is of the opinion that an individual economic gain must not outweigh the harmful effects of the practice on the girl child. In spite of all this argument, the Joint Committee is of the opinion that cultural or traditional practice must not impinge on the rights and freedom of others, especially their health rights. So the other part, justification against the repeal of the Act. 1. National, regional, international conventions and laws. The Gambia also enacted domestic laws, in particular the Children Act 2005, the Women Act of 2015, Amendment Act of 2015 and its amendment, the provision of FGMC reflecting the country's 39 commitment to protecting its women and girls from harmful practice, which is a gross violation of their human rights. The repeal of the Women Amendment Act of 2015 will also violate the fundamental rights of freedoms provided for under Chapter 4 of the Constitution, as the cultural practice of FGMC contravenes the provision contained therein. Chapter 4 of the 1997 Constitution of the Republic of the Gambia protects fundamental rights and freedom, in particular the following sections, which I will quote. Section 18, the right to life. In certain instances, the practice of FGM has even led to death of girls and women, thereby violating this fundamental right. Section 21, no person shall be subjected to torture or inhumane degrading treatment. Traumatic way the practice is carried out as recounted by many survivors. Section 28, rights of women to dignity. Women shall be accorded full and equal dignity of the person with men. Section 29, right of children, which also provides that legislation enacted in the best interests of children. Section 33 protects from discrimination and further provides under Section 33(2) that no law shall make any provision which is discriminatory in either of itself or in its effect. Furthermore, the Gambia is a signatory to the Conventions on the Elimination of All Forms of Discrimination Against Women, that is the CEDAW, the Beijing Declaration and Platform for Action, 1995, the Convention on the Rights of the Child, CRC, the African Charter on the Rights and Welfare of the Child, the African Union Solemn Declaration on Gender Equality in Africa, and the MAPRO Protocol. The Gambia ratified the CRC on 9 August 1990, CEDAW on 6 April 1993, the African Children Charter on 14 December 2000, and the MAPRO Protocol on 25 May 2005. It enacted the Women Act in 2010 and subsequent Women Amendment Act in 2015. 2. Violation of the right to health. The right to health is a fundamental human right for all, which is guaranteed in the 1997 Constitution and several international regional instruments the Gambia is a party to. The repeal of the law will allow the continued practice of FGMC, which is a serious violation of the right to health and is proven to be causing severe physical and emotional harm to women and girls. The procedure is often performed without proper medical care, leading to complications such as bleeding, leading to shock, transmission of infection, injuries to adjacent organs, dyspareunia, anorgasmia, paraclitoral cysts, and chronic pain. It is also possesses obstetric risks such as prolonged labor, increased cesarean section rates, increased rates of episiotomy, perineal tears, postpartum hemorrhage, and increased perinatal complications. In some circumstances, FGMC has even led to death, thereby violating the right to life as provided for under Section 18 of the Constitution. FGMC survivors in the Gambia and different parts of the world have given account of psychological effects of the practice on them due to inhumane, traumatic way it is carried out. Such recounts indicate a violation of the right to the highest attainable standard of physical and mental health. 3. Setback for gender equality in the Gambia. FGMC is a human rights violation and also a deeply rooted practice that discriminates based on sex, gender, age, and other grounds, which expressly contradicts the principles of non-discrimination provided in Section 33 of the 1997 Constitution. Repealing the law will be a significant setback for Gambia's efforts to enhance the welfare of women and girls in the country, along with attaining their economic empowerment. 4. Community development. Rejecting the repeal of the law is essential for promoting progressive social change and community development. It encourages dialogue, education, and awareness-raising initiatives to challenge harmful cultural norms and practices that affect women and girls in society. The committee is of the opinion that the National Assembly strives for a more enlightened and inclusive society where everyone can live freely from violence and discrimination. Of course, we were opportune to conduct a study tour to Cairo, Egypt, which we also take note of. The study tour to Egypt, conducted by members of the Joint Committee of Gender and Health and other parliamentarians from the 9th to 14th June 2024, was aimed to explore the strategies, policies, and community practices that effectively address female genital mutilation in Egypt. The delegation met various religious leaders and experts from Al-Azhar University, Egyptian National Council for Women, members of parliament, and civil society members. The delegation comprised of honorable members of the Joint Committee on Health and Gender, other National Assembly members, and support staff of the National Assembly. The visits sought to gather insights and best practices to make informed decisions regarding FGM. The history of female genital mutilation in Egypt is marked by a transition from traditional practices to medicalization, followed by legislative efforts aimed at eradication. In the mid-20th century, FGM began to be medicalized to reduce severe complications, allowing health professionals to perform circumcision. By 1994, the Egyptian Ministry of Health permitted FGM under certain medical conditions. Notably, Egypt, along with other African and Middle East countries, had high rates of medicalized FGM. with 79% of procedures in 2015 conducted by medical professionals. This shift aimed to reduce health risks, but inadvertently legitimize the practice rather. Significant legislative progress occurred in 1996 when a decree prohibited FGM in government health facilities. This was expanded in 2007 to ban all forms of FGM by both medical and non-medical personnel. In 2008, amendments to the child law explicitly criminalized FGM, and further amendments in 2016 and 2020 increased penalties and extended accountability. Despite these comprehensive legal measures, enforcement challenges and deep-rooted cultural norms persist. Ongoing efforts by the government, NGOs, and international organizations aim to change societal attitudes and ensure the law is upheld. This underscores the importance of strong legal framework and sustained public education. The study too aimed to understand Egypt's strategies and legislative framework against FGM, learn from successful programs, observe community-based interventions, and study healthcare approaches to prevent and treat FGM-related complications. Discussion covered the scientific background of FGM, its medicalization, and ethical concern, as well as the negative consequences of the practice. The religious perspective clarified that FGM lacks a basis in Islam, supporting advocacy against it. National efforts to combat FGM were highlighted, emphasizing the crucial role of political leaders and parliamentarians in engaging communities and supporting the elimination of FGM. So the lessons learned, Honorable Speaker, from the study in Egypt. One, female genital mutilation is not Islamic, but custom, tradition, or belief, traditional belief. FGM is a rooted cultural tradition rather than religious teachings. Islamic scholars have clarified that it is not a requirement of Islam, helping to debunk the myth that it has religious significance. This understanding can aid in changing community attitudes towards the practice. Two, all Islamic scholars speak with one voice to produce an overall fatwa against FGM. Islamic scholars in Egypt have issued a unified fatwa against FGM, declaring it non-Islamic and harmful. This consensus provides a strong religious foundation for anti-FGM advocacy. It supports efforts to educate communities and discourage the practice. 3. FGM is more of a humanitarian issue than a national issue. FGM is primarily a violation of human rights, impacting health and well-being of women and girls. Addressing it requires a focus on humanitarian aspects rather than just national legalities. It's called for global attention and coordinated human rights efforts. 4. The Gambia's act against FGM is far better than that of the Egyptian law. The Gambia legislation against FGM is more comprehensive and effective compared to Egypt. It includes stringent penalties and robust enforcement measures. This highlights the need for stronger legal framework and enforcement in Egypt. 5. FGM is not performed in Saudi Arabia. Therefore, they have no information regarding FGM. FGM is not common practice in Saudi Arabia, resulting in limited information on the subject. This indicates that FGM is not universally tied to Islamic practice. It underscored the cultural rather than religious basis of FGM. 6. Prophet Muhammad sallallahu alaihi wasallam, peace be upon him, brother, daughters were not circumcised. Historical evidence shows that daughters of Prophet Muhammad, peace be upon him, were not subjected to FGM. This fact helps to refute the notion that FGM is a religious obligation in Islam. It provides a strong argument for anti-FGM advocacy based on religious history. Honorable Speaker, recommendation of the Joint Committee. Please, decorum, please. Recommendation of the Joint Committee. This is very important, please. The Joint Committee, having considered and scrutinized the bill and had various experts and opinions, hereby recommends as follows. 1. That the Women Amendment Act 2015 be maintained to prohibit female circumcision in all forms, whether genital mutilation or cutting in the Gambia. 2. Protects women's health and well-being. Repealing the ban on FGMC would expose women and girls to severe health risks and violate their rights to physical and mental well-being. The practice of FGMC has been consistently linked to numerous health complications, including chronic pain, infection, obstetric risks, and psychological trauma. Preserving the ban is essential for safeguarding the health and dignity of women and girls in the Gambia. 3. Promote gender equality and social development. The continuation of FGMC perpetuates harmful gender inequalities and girls. By maintaining the ban, the Gambia can reaffirm its commitment to gender equality and promote social development by challenging harmful cultural norms and practices. Rejecting the repeal of the FGMC ban is crucial for fostering an inclusive society where everyone can thrive free from violence and discrimination. 4. Legal support and protection. Girls and women who are at risk have undergone FGMC should have access to legal support and protection. These include access to shelters, counseling, and other support services. 5. Research and data collection. Continued research and data collection are necessary to understand the prevalence of FGMC, its impact on individuals and communities, and the effectiveness of interventions aimed at preventing and addressing it. 6. Legislation and policy. Governments should enforce law as well as issue clear policy directives prohibiting FGMC and provide continued legal protections for girls and women at risk. 7. Awareness and education. Comprehensive public awareness campaign and educational programs should be implemented to raise awareness about the harmful effects of FGMC and promote gender equality and women. 8. Healthcare interventions. Healthcare providers should be trained to recognize and address the physical and psychological consequences of FGMC. They should also provide support for medical care for girls and women who have undergone FGMC. 9. Honorable Speaker, to clearly ban any attempt to medicalize the practice of FGMC. Conclusion, Honorable Speaker. The Gambia's commitment to national, regional, and international conventions such as the CEDAW, which I quoted earlier, the CRT, and the famous Maputo Protocol reflects its dedication to eliminating discrimination and promoting gender equality. The practice of female genital mutilation or cutting directly violates this commitment by infringing upon the fundamental rights to health, causing severe physical and psychological harm to women and girls. Allowing FGMC to continue undermines gender equality and perpetuates abuse, discrimination, contradicting the principles enshrined in the 1997 Constitution. Repealing laws against FGMC would not only violate human rights, but also hinder community development and the country's progress toward a more inclusive and equitable society. It is essential to uphold and enforce laws against FGMC to protect women's and children's rights and foster a progressive social change in the Gambia. Honorable Speaker, with these remarks, the Joint Committee hereby propose and move with its attached recommendations and conclusion that this Honorable August Assembly do adopt this report. Thank you very much.
Thank you, Honorable Member for Nyanija and Co-Chair of the Joint Committee. Honorable members, may I on your behalf acknowledge the presence of the Honorable Minister for Gender, Children and Social Welfare in our midst in the chambers. You are most welcome, and we thank you for being here with your technical backup. Honorable members, any honorable member who may want to second the motion? Honorable Member for Jara Central.
Thank you very much, Honorable Speaker, for giving me the opportunity. Honorable Speaker, I rise to second the motion and equally would want to move a motion, orders 61.2 and 61.3. for the fact that we have only 1 hour to debate, I want to limit allot 3 minutes for every member who would want to partake in the debate. Thank you.
Honorable Minority Leader and member for Bikamano.
3 minutes.
Second the motion.
Honorable members, it has been moved and seconded that the time of 3 minutes be allotted to each member during the debate. Those in favor, please say aye. Those not in favor, please say no.
No.
The ayes have it.
I call for division.
You call on division?
Division, yes.
Okay. Division, okay. I will now put the question and members you raise your tag if we are for the motion and if you are against the motion. Honorable members, those who are in for the motion to attach 3 minutes to each member for the debate, please raise your tags. Honorable members, those not in favor, raise your tags. Not in favor. Honorable members, those abstaining, abstentions. Honorable members, please. Honorable, the results of the votes. Those in favor, 28. Those against, no, 12. Abstention, 4. The ayes have it. The debate will now be timed to 3 minutes for each member. And Honorable Member for Gara Central, you want to proceed. You moved the motion and you said you want to second the motion.
Yeah, I will proceed. I will debate later, not now.
Okay.
I have the right to second the motion and then debate later.
Honorable member for Latikunda, are you rising up to a point of order? Are you rising up to a point of order?
No, an observation.
Observation of order.
Yes, observe. There is a second petition. Anybody who is a second motion will debate. There is a second petition.
Honorable member. And I will begin with Honorable Member for Foni Kansala.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله على نعمة الإسلام وكفى بالله نعمة. I thank Honorable Speaker and the Chairman of the committee. I am sorry to inform this committee, the two joint committees, that they have betrayed the trust of Muslims in the report. Order. Yes. They have betrayed the trust of the Muslims in the report, and they have betrayed the trust of the traditional leaders in this report.
Speaker, no. Speaker, no.
This is a report that should be reflected
when we call
the Muslims.
Point of order, Mr. Speaker.
I am page by page with this report. And I believe